Thank you very much for giving me the floor. I'm the spokesperson of the Association of Judges, of Polish Judges Themis. It's a great honor to have ability to tell you what is going on in Poland, especially that we are at the kind of turning point for the independence of Polish judiciary, because in April this year the term of office of current first president of Supreme Court, Ms. Małgorzata Gerstaw, expires, and at that moment probably there will be the new president appointed without serious help in from European Union, namely application of interim measures. I'm afraid that it will be completely politically dependent new president, and such kind of action, the defeat of the last standing central judicial authority which is independent, can break the spin bones of judges of ordinary courts. Very shortly about the changes in Polish judiciary, in Polish legal system. They all started from taking control over Constitutional Tribunal. It was unconstitutional and taken over, and this means that very small law and justice majorities of seats in parliament is able to adopt any law, even unconstitutional. Afterwards, the ruling camp took political control over the Public Prosecutor Office, which was achieved by combining functions of Minister of Justice and Public Prosecutor General, which has been accompanied by a significant increase of his investigative powers. And Minister of Justice has been enabled to appoint the superior prosecutors instead of competition procedure applied before, and it was accompanied by exchange of top prosecutors under the pretext of reorganization, and the result of these changes is the image of Public Prosecutor Office as potentially entirely disposed to the ruling party. What is more, at the very top of the Public Prosecution Office, the Internal Affairs Department of the State Prosecution Service was created, which statutory aim is to conduct and supervise preparatory proceedings in cases of crimes committed by judges and prosecutors. During more than 2 years of its operation, they commenced 2 proceedings against specific judges. If we take under consideration that there is 10,000 judges in Poland, this number is insignificant, and it clearly shows that this special unit was created just to incite the chilling effect among the judges. Afterwards, we were facing the amendment of the Act on the Organization of Ordinary Courts, which enabled the Minister of Justice to arbitrarily dismiss presidents and vice presidents of courts, and Minister of Justice do it in respect of about 160 persons before their terms of office expired, and the new presidents were appointed who are absolutely loyal to the ruling camp, and many of them now exercise their power by applying soft administrative measures of repression in respect of defiant judges. Afterwards, the complete part was done within the National Council of the Judiciary, which had previously played a fundamental role in safeguarding of the independence of the judiciary, because the main constitutional right of this body, the obligation, is protection of judicial independence. So this body evaluates candidates for judges, candidates for higher judicial positions, and has the right to set out the rules of professional ethics for judges. Contrary to our constitution, the prerogative of appointing 15 judges members was transferred from judicial self-governing bodies to the Polish Parliament, and simultaneously they terminated the terms of office of the members of the old council. In fact, the new members of National Council of the Judiciary, according to the new law, were obliged to gather 25 signatures of support from other judges, but this list of support have never been revealed to the public, So we don't know if even according to this new regulation, these members of NEO-NCJ were correctly elected. These lists were never revealed in spite of the valid sentence of the Supreme Administrative Court. And this Neo-National Council of the Judiciary was turned from the effective guardian of judicial independence into body suppressing independence of the judiciary. For example, when they assessed judges for the promotion, previously it was like that the judges who were best evaluated by the local assemblies of courts, by the judges' visitors, were promoted. Now, those judges who are the worst are promoted by NEO-NCJ because they guarantee absolute loyalty to the ruling camp. And there was motives of one of the decision of NEO-NCJ why they promoted the worst judge. It was written exactly like that. The fact that this judge has very high rate of verdicts quashed by the second instance proves his independent way of thinking. I would add this independent way of thinking from logic and from professionalism. And there is, of course, huge number of personal direct connections between members of NEO-NCJ and Ministry of Justice. Most of members of this new body were promoted by the Minister of Justice and they became the presidents of the courts. Now let's move to the new act on the Supreme Court. Originally, it was drawn up to enable a part of the personnel in this highest judicial body by the reduction of the retirement age for judges. Of course, it was stopped in October 2018 by the interim measure applied by the Court of Justice of European Union. But in spite of that, there were created two entirely new chambers within the Supreme Court, which are strictly politically subordinated. From the point of view of judges, the most important body is the Disciplinary Chamber, which is the second instance court in disciplinary proceedings in respect of judges. And I must add that this Disciplinary Chamber has its own president, completely independent from the first president of Supreme Court, own budget, own office, own spokesperson, and own rules of the procedure. So in fact, it is completely new court, just acting under the auspices of the Supreme Court. This court is not provided by the Constitution. So the creation of such specialized court is possible only in times of war. So it is not a court provided by law in the meaning of Article 6 of European Convention of Human Rights. And the mode of election of the new judges to this disciplinary chamber and the second new chamber was in fact quite fun. It remained rather the beauty contest than the real competition for the high professional position, because the Neo-National Council of the Judiciary skipped requirements concerning examination of the files of the candidates. So the only one criterion of assessment was the talk between the candidate and three members of NEO-NCJ, which lasted between 8 and 15 minutes. So in fact, it is much easier now to become a judge of ordinary court than a judge of the Supreme Court. So it shows that not professional reasons stood behind the decision on nomination to this disciplinary chamber. Alongside with the disciplinary chamber, there was simultaneously introduced the new mode of disciplinary proceedings in respect of judges, which massively undermines the right to the defense, because it is permissible to carry out a hearing in disciplinary proceeding in justified absence of the judge and his counsel, and it is possible to apply evidence obtained without judicial control and in violation of law, including the evidence from operational telephone typing. And what is even more, the Minister of Justice appoints the main disciplinary commissioner for judges and his two deputies, and all judges in the first instance disciplinary courts. The Minister of Justice has overwhelming personal influence on the new mode of disciplinary proceedings. So in fact, it is an inquisitional model of disciplinary proceedings against judges, which politicized the proceedings and massively restricted the procedural right of the defendants. We can differentiate two ways of frightening judges, of intimidating judges, of putting pressure. First, we can call them hard measures, which are possibility of commencing disciplinary proceedings, and the second branch of these hard measures is commencing criminal proceedings. As you can see from this slide, the pretrial proceedings in respect of defiant judges is always commenced by central disciplinary commissioners appointed by the Minister of Justice. At the trial stage, the judges of first instance were all appointed by the Minister of Justice arbitrarily, and in the second instance, we face the Disciplinary Chamber of the Supreme Court, which members were appointed by Neo-National Council of the Judiciary with indirect influence of the Minister of Justice. And if the power camp wants to instigate criminal proceedings in respect of judge, it has at the disposal the Internal Affairs Department of the State Prosecution Service at the top of the prosecution. So we are surrounded from every direction. We have also these soft measures of repression, which are applied mainly by the presidents of courts, newly appointed, and the Minister of Justice. And there is quite wide range of measures like transfer judges between divisions, deteriorating of working conditions, liquidation of division of court in order to deprive particular judge of functions, and many other measures. What are the typical categories of sensitive cases in which these soft or hard measures can be applied? It is applied in respect of judges who refer preliminary requests to the Court of Justice of European Union, judges who decide directly on the basis of constitution or international law, judges protesting against the breach of constitution, politicization of the judiciary, judges involved in legal education of children. Quite recently, we were facing the very serious black PR campaign against judges, which was called billboard campaign. We have 1,000 great billboards around all Poland describing some real, some alleged, some manipulated situations of misbehavior of judges. One real situation was that the judge has stolen trousers from the shop. This situation has happened, but they didn't mention that the judge was for many years retired and that he was mentally ill. And there were such a huge billboard, and one of the judges very accurately commented that the situation in which one of branches of state authority pays to organize negative campaign against another branch of state authority of the same country is so peculiar that even George Orwell or Monty Python couldn't have come up with that. And that is absolutely true. Afterwards, we have a wave of speeches of our Prime Minister saying that Polish judiciary is a part of post-communist pact, which is a paradox, as the average judge is 42 and the change of the system was 30 years ago. The information that Polish judges are corrupted, which is absolutely not confirmed by the statistics and by the Greco reports. And at one of the meetings with President Macron, Polish Prime Minister compared Polish judges and Polish courts to the courts of Vichy France, collaborating with the Nazis. And quite recently we faced so-called troll farm in the Ministry of Justice. So there was a group of 12 judges rooted in the Ministry of Justice who organized a smear campaign against the defiant judges. One of their famous actions was inciting in the internet the public to send postcards to the first president of Polish Supreme Court, get the fuck off from the Supreme Court. In this group, There were involved 3 members of Neo-National Council of the Judiciary, 2 deputies of the main disciplinary commissioners, and 1 of the members, new judges of the Disciplinary Chamber. So this example clearly shows that all newly created bodies are morally compromised and politically corrupted. What else?
Can I ask you to
go
towards a conclusion?
Okay. Conclusion. What is the conclusion? 2 politicized committees were created in order to subordinate Polish judiciary. One is Neo-National Council of the Judiciary, which is responsible for appointment and promotion of judges. So, in general, that they pump new judges to the top positions who are absolutely loyal to the ruling camp. And the second such committee, politicized committee, is Disciplinary Chamber of the Supreme Court, which is responsible for legal harassment of defiant judges. So we have very nice equilibrium. One body is pulling new loyal judges, another one is going to throw out these who are not loyal to the politicians. There is full control of the Minister of Justice over the Prosecutor's Office, over the disciplinary proceedings, an excessive level of administrative control over the judiciary, and such very strong position of Minister of Justice has great potential of intimidating of judges, and it is a real chilling effect generator. The idea of political subordination of the judiciary is supported by the massive Black PR campaign, including media, internet, billboards. All these forms of slandering of the judiciary and particular judges are either organized and financed or at least supported by the executive. This internet part of negative campaign against judges is clearly, completely Putin-like project, and all these tools of oppression, which I tried to describe within 10 minutes, are engaged to suppress judicial independence and to disable application of the European Union law by the Polish courts.